All right, and welcome everyone. This is actually the final webinar of 2022. We've had over 20, I think it's maybe 21 webinars that we've had this year. So thank you so much for joining us. I am happy to have Margaret Todd here with the Agricultural Law Education Initiative. They're a great partner with us and offer some wonderful topics on lots of legal issues. And today she's going to be speaking on understanding property purchase agreements. So with that, I'm going to turn our lunchtime over to Margaret.
Great. Thank you, Shannon. Yeah, as you mentioned, ALEI, I always love working with Extension. So it's always fun to work on projects. As Shannon mentioned, my name is Margaret Todd. I go by Megan. I'm a legal research associate with the Ag Law Education Initiative. If you haven't, there we go. If you haven't heard of ALEI before, we are basically, in a nutshell, a partnership of 3 University of Maryland schools or colleges with lawyers from each school. We collaborate and make sure that we're creating free resources and educational events to serve Maryland's agricultural community. All free resources on a variety of legal topics that come up when you're running a farm business. Check out our website, umaglaw.org. You can go to our publications library or video library, see what we have. If you have any questions about what you see there, or if you can't find something to answer your question, please feel free to reach out either at our general email address there, or my contact information will be at the end of the presentation. I'm always happy to get questions and help out as we can. And then, of course, because I'm a lawyer, we have to put a disclaimer that the talk today is for educational purposes only, not meant to be legal advice or anything like that. But and we always say, if you do want some legal representation or advice about your individual situation, to seek an attorney. So today we are talking about understanding property purchase agreements, and I'll talk about some of the terms that come up often and how you can best protect your rights during that process. But before I get into that too much, I'm going to talk about a few preliminary matters that go into planning for a purchase of property, and then also touch on at the very end quickly the ag transfer tax document, which is typically included in a rural farmland purchase. So the terms of planning for purchasing land, it's going to take a lot. These types of transactions don't happen quickly, and they're very costly. And so it's really important that before you get the idea that you want to buy land, it's important for you to sit down and assess what your priorities are, and thinking about the different pros and cons that are involved in owning property. Right, some of the pros of owning property are that you have there's more security in the land and your operation. You have this longevity as you make payments into it. You're building equity, and it's a great source of collateral if you need to take out operating loans in the future. It's basically a legacy. There's lots of great pros for owning property, but on the other side, it can tie up a lot of your assets. It is a very potentially large source of debt for you. And it might be the security aspect goes both ways, and that it's a very permanent asset that may have little flexibility. And so a lot of what I'm going to talk about today is talking about doing some research to make sure that property is going to suit your needs. And so planning ahead of time to think about what is your operation now and what are your plans for the future, and expanding your business, because it may turn out at some point the property is not going to suit your needs, and how will you handle it when that comes up? And so an example would be some types of uses that maybe as you build your business, expand your operation, you're going to start doing agritourism events, like having members of the public come onto your property, or hosting educational events. Maybe you're going to start a CSA or expand your CSA, or even start a food production, a value-added business component to your farm. What are the types of facilities that you would need to accomplish that, and would the zoning of your piece of property allow for that, and as well as other restrictions that we'll talk about in the next few slides. So planning, thinking about your business and where you want to go, all of that stuff is really important as a step, we know, for many reasons, but even in buying a piece of property, it's important to do that forethought as well. And also thinking about the definition of agriculture. I think this is something that a lot of communities, like counties, are moving toward in terms of adopting an official definition within their county, but also remembering, in Maryland, we do have a model definition that counties can adopt, but they can also modify it or change it. So don't assume that the state model definition applies in every county. Take the time to research, thinking about where you may want to buy land, and what is that county's definition of agriculture, and what are their restrictions on what you can do as a right on your property versus what is disallowed. So thinking about that types of information as well. Financial readiness is, of course, a very large part, and I won't go too much into it today, but just keeping it in mind for a lot of different reasons. Of course, the first would be personal finance or your farm business finances, making sure that you can afford, or thinking about how much land you can afford to buy at first. There are a lot of expenses involved in buying land. We'll talk about it in a minute, but it's not just as upfront as like, what's the sticker price, the asking price on a piece of property or a listing. There's gonna be a lot more things involved. And so thinking for yourself, like, what are your ownership options when you want to buy a piece of property? Do you want to be a sole owner? Is your business going to be the owner of the property, where so there's two options. You can own it personally and your business would rent it from you, or maybe the business itself would be the owner and renting from itself. Or if you have business partners, if you're part of a farm corporation or a co-op or an LLC and you have partners, co-owning is a way to reduce your own individual expenses, right? Your financial. So if you can share that expense, and if that's possible to bring partners in, if you want to have those shared responsibilities for the land, thinking about how are you going to suss out percentages of ownership and responsibilities and things like that before you go into making an offer for a piece of property. I have listed here on the slides that you will have access to later a number of good resources. LFG stands for Land for Good, which is an organization based out of New Hampshire, I think, but they've got a number of really great resources on their website that help you go through some of those pre-planning steps for financing and business planning, things like that, to help you sort of organize your thoughts and what are your priorities in your business, but also in a piece of property that you may want to buy and to suit your business needs. So I highly encourage you to check out those resources as well. They're free for the most part. You just have to sign up for an account, but that's it in order to access a lot of the materials. And then we have the Young Farmers Coalition. They also have some really great resources. I'll link a few throughout the slideshow for you to refer to as well, to do further reading to help you prepare as you approach, get closer and closer to actually buying a piece of property. And then, of course, we have Beginning Farmer Program at the University of Maryland Extension. We have a great Beginning Farmer Guide that includes some chapters on assessing farmland, doing some background into zoning and land use abilities and doing that transaction. For financing, I think for farm purchasing and financing, it's a little bit different than residential or home buying, right? A lot of times you may be familiar with the idea of getting pre-qualified for a loan. So you can go out and shop for some properties to see what's within your shop for properties that are within your approval range, right? You know what you can spend ahead of time. And with farm loans, it's a little bit different. You may often be working with multiple lenders, either private commercial banks, farm credit, which is actually like a co-op, in addition to like the USDA Farm Service Agency or Morbidco, or maybe all three together. I don't know if that's possible, but typically what would happen though in a real property financing agreement though is you can't get pre-qualified necessarily. You may be able to do it with a private lender or farm credit, But with Farm Service Agency, you don't get pre-approval, right? You go in, they'll cover up to $600,000 potentially of a purchase expense, and you have to work with a commercial lender. But you kind of take, once you put the offer in on the property, you have a purchase agreement, and you have a whole host of other information that you have to provide to them as well, along with business plans, things like that. Then they will take your application and you'll get approval at some point. Thankfully, you can always contact your Farm Service Agency, talk with loan officers there in advance, understand the process and get familiar with the application in advance before you go into making an offer and doing a purchase agreement. So you have all that information ready to go when you do make an offer. And important to note that because you can't get pre-qualified, I'll talk about contingencies later, but contingency on a loan approval will be one of those terms that you want to include in your purchase agreement as a way to protect yourself if your financing doesn't come through. But so even though this is like a do it ahead of time, but also during the actual purchase process, the offer and the purchase agreement process. But these are great programs. I highly encourage you to check out what the different offerings. They have it for property acquisition, for operating loans combined, different uses. Marbitco has a variety of different loan programs as well. They'll do micro loans for some things, and they also can put large amounts, up to 40% of a property purchase, but I think no more than $600,000, as long as you're also working with another lender. So great programs. I highly encourage you to talk about. And as the list shows here, you will need to have that information ahead of time to do the application. And then when it comes to actually looking for your piece of property, there are a lot of resources. It's can also be a very time-consuming process. Just doing the research, trying to find properties that you're interested in that suit your needs. That if you put your priority list together and think, have an idea of where you want to be, maybe. There are a lot of great resources out there, like FarmLink programs in Maryland and Pennsylvania and Virginia. Working with your local agricultural service providers is also a great idea. If you have a county economic development office, they may be able to help you. And then, of course, working with a realtor who's experienced in farmland transactions is always a great way to go. They're really plugged into the market and what's coming up on the market. So there may be something to, and as you shop around, and the more you get prepared and the more serious you are, you're going to want to get in touch with a realtor and maybe do a realtor agreement, which I'll talk about in a few slides. But that's a really great way to identify land that's available to you. If you're looking for more urban settings, loopnet.com is actually a resource I recently found out about for helping you identify properties that are like commercially zoned, like warehouses. If you're looking for a retail space, something like that, if you want to do controlled environment ag, that's a great listing website. If you're in Baltimore City, the Office of Sustainability and Urban Agriculture may be a good resource. I know that there's been some difficulty in the past, like with the office helping to connect farmers to available parcels in the city. I think they're trying to make more efforts to get that done. They recently had a request for proposals for some parcels that they have available. And I'm not sure if they're going to continue that in the future, but reaching out and talking to them about it would be a great idea if you're interested in farming within Baltimore City. And then if you're interested in maybe other states, maybe you want to move out of state, the Land Access Advocacy Network has a webpage with some links to different resources for finding farmland in other states. So that may be a good place for you to start to get into that type of research. I included this picture here of an expert from a New York Times article. I don't want to go too far down the rabbit hole, but I just wanted to bring up the point that it can be possibly really frustrating in this point in time, I think post-pandemic, right? Since 2020, when people are trying to find like quarantine properties, or, there's this higher instances where deep-pocketed investors or private individuals are kind of snatching up properties in every market. I feel like all the markets are getting really skyrocketing, and they're able to put in, cash offers with no contingencies, which is really bad for like the little guy who needs to protect themselves, and they have to, they can't afford to take a hit if they're not planning to do a total renovation, right, on a piece of property. They want to be able to move in and start living there or using the land. So I just bring that up because, I feel like the market's very competitive, and I'm going to be talking a lot today about contingencies and how to protect yourself. And so just making sure that it's important to not succumb to like market pressure if they're asking you to like waive contingencies or waive inspections. You really have to make an assessment if that's good for you. And a lot of times the answer is going to be no, because you're exposing yourself to more risk if you do that. But if you're willing and able to do that, then that could be an option for you. And just saying that, sort of like that letter to the seller, putting together your business plan, putting together your branding and your business story can be a really critical pre-purchase activity. And as a way to help the seller connect with you as a buyer during the negotiation process, to maybe sway them your way more, if that's something that could help you. So yeah, don't want to go down too far down the rabbit hole, but that is something, acknowledge that. And then of course, as a stepping stone to actually buying the property, you're going to be leasing the property, which is always a really great option to help you kind of get your feet wet. Like, if you're starting out and you never farmed before, leasing is usually the way to go. Even if you're an established business, leasing is also a really great option. You have the ability to see what types of setups will work for you, to maybe build a relationship with other farmers in the area and your neighbors. And maybe you can find a landowner who at some point in the future is willing to do a land contract with you, or like gradually transfer ownership to you through the leasing agreement setup. So that'd be a really great plus if that's ability, you have the ability to do that. But I just wanted to also highlight a resource ALEI just released, which is an ag lease builder website to help you build up a lease for your either a landowner or the tenant can use it. It's really quick and easy to use. And especially if you're considering doing some conservation practices on the property, on your farm, that helps you incorporate some of those terms into the lease agreement. The website for that is agleasebuilder.org, which you will be able to click on that link when you get the slideshow. Okay. Trying to go quickly here so we can get through all the slides before the hour is over. Okay, so some of the terms and the documents that are involved in farmland purchases, I will quickly go over this list. So it usually starts out with like the offer to purchase, which is basically the buyer, the seller will list it, they'll have a listing price, right? And so the offer can be below listing price, and you may have a reason for it. And you offer the seller what you're willing to pay. A lot of times the seller is going to come back with a counter offer of some sort, changing the terms. You go back and forth, negotiate as you may. If the seller finds your first offer sort of attractive, but maybe they want to change some stuff. But bottom line is, like, once both sides agree to the terms that have been negotiated and sign the agreements, it becomes a legally binding contract, which will be converted to the purchase agreement. And so if you have an offer that's signed by all the parties, and that's it, that's legally binding. You can put in an offer, an expiration date, like if they only have like a week to think about it and get back to you to either turn it down or make another counter offer. You can put that type of term in there if you'd like. You have, like I said, it turns into the purchase agreement. Those terms are like, put in together. And that purchase agreement will contain all the terms of the agreement. We'll talk about some of the standard terms that would be included in a purchase agreement in Maryland in the next few slides. But you also have, in addition to that, a lot of addendum, which we'll talk about a little bit, but it can include things like easement contracts. If you have a dual agency agreement, it'll include that. a variety of things can be included in the addendum. So always keep your eye out for those documents, because even though they're addendum, they're not part of like the main contract. They are actually part of the contract and very important to understand and read beforehand before you sign anything. Then you'll hear escrow. Escrow relates to like this like neutral account where you would pay your earnest money into when you make your offer. And that's the account that you would pay your make the payment into as well. And it's just sort of like a third party holding account, making sure that nobody can use that money before the transaction is completed. Then you'll have the promissory note or loan agreement, which is basically the financing documents that you'll be working out with your financing with your banks. You'll have your deed, which is the physical document you will have to sign. It includes the names of the parties, a description of the property, which is typically called the legal description of the property. It should include a description of any types of restrictions that go along with the transfer of the property. And then both parties will sign that, and it gets recorded with the Office of Land Records to officially memorialize the transfer of property. You'll have a mortgage or a deed of trust. So the mortgage is basically, your pledge to the bank, the financer, that you're putting that property up as collateral if you default on your payments, and the bank can take it back. A deed of trust is really similar, but it kind of adds in a neutral third party like the title company. So if you default, the title company would be the trustee of the property and hold the title, the deed, but letting the owner use the property. So it's just a difference in one or the other. They basically mean the same thing. Then you'd have a title insurance policy. So a lot of times you're going to want to have, like you will buy the property, and the buyer will ask for the property, the title, to be sort of like free and clear of all liens and encumbrances. And because land records can be really hard to read or really convoluted, like spread out, you'll hire a title company to do some research to see if there's any sort of like liens that are hiding back in the records, or other encumbrances, easements, things like that. And basically they'll provide an insurance policy to say that yes, it should, it's free and clear. If anything comes up, they will have, as the policy, you would read the policy terms to see what instances the buyer would be entitled to any sort of compensation if there is something that comes up in the title after you've closed the transaction. Then you'll have seller's disclosures or property disclosures. And these should include anything that's, there's going to be certain disclosures by law, things like if there's a residence on the property, if there's lead-based paint been used in the house, that's a required disclosure. If the seller knows about any sort of like pest infestations or like renovations that were done without a permit, or water damage, oftentimes, those are the types of things that are going to be disclosed, or any other types of defects on the property that can affect the value of the property. Then you'll also have an agricultural declaration of intent, which is also the ag transfer tax. And so if you are trying to buy a piece of property that is within an agricultural use assessment already, so it's being used for agriculture, that's usually subject to a much lower real estate property tax than regular like commercial properties. And so you'd have to write or sign a document that you intend to also use it for agricultural purposes to receive that lower tax rate. And if you don't, then you could potentially be subject, pay a lot more back taxes on the property. And then you also have the closing statement in the transaction. And this is going to include a lot of just kind of the fees that are involved, a listing of all the fees, the financing terms. So you'll have like agent fees, closing fees, all kinds of stuff that you'll also be paying in addition to the purchase price of the property. So that's your opportunity to really go through and find the itemized list and track all those expenses and who's paying what, you know, the buyer versus the seller. And so going through all those documents is really important, but those are kind of like all of the things that are involved in a real estate transaction. Again, here are some more resources listed that are really helpful to help you understand that process in like a step-by-step way. And I also will send along with a copy of my slides, a standard land purchase agreement for Maryland. That's very default, but remembering that you can, these terms are very default and common, but can also be adjusted if needed. Okay, so first we'll talk a little bit more about offer, counter offer, and contract. So if you make an offer on a piece of property, keep in mind that you can rescind that offer at any time before the seller signs it or makes the counter offer. And you can, like I said, you can specify when your offer expires. So if you only give them like 24 hours to consider it, you can do that. I'm not sure how the seller would like that, but that's within your power to do. Seller can then change the terms, like I said, if they want if they're not okay with some of the things, and that becomes the counter offer. And then if they're both signed, it becomes the contract. I will just mention quickly that there is another phrase that's you may have heard. It's called letter of intent. And so that's something that you would do, like if you're not comfortable enough to make an offer yet, and you just want to send something that like letting the seller know that you're interested in the property and that you're thinking about making this offer and kind of outlining it for them, and then getting some feedback from the seller, like, well, would they accept it or would they not? That's something that you could also do. But a letter of intent is not an offer. So, you know, you'd have to take all that extra time of like drafting your letter of intent, then sending it over, waiting to hear back. And in the meantime, somebody else could be putting an offer in, which would be, you know, potentially legally binding if the seller were to accept it. So that's also an option, but could be in this type of market, it could be something that would just waste time if you could make an offer instead. And like I said, because it would become a legally binding contract once all the parties sign and agree to it, don't sign it until you're absolutely sure that you like all the terms or understand all the terms. So purchase agreements, here's a snapshot of what the front page looks like, and I will send a copy of this out to the registrants. A lot of the terms, there's a lot of terms in there, but typically you're going to see the price, of course, the purchase price, how much earnest money for the deposit, which typically goes along with the offer, the date that you want to close on the property, contingencies and the time frame. So you'll have like a contingency period. A lot of times it's 90 days, which is the time frame that you have to conduct sort of your due diligence steps, which we'll talk about. And if after that period you still sign the purchase agreement, you know, that still goes into effect. You've got property disclosures, like I mentioned. You've got other details about like utilities, property taxes, other fees, and then a lot of details about who pays for the inspections, the surveys, if you want one, title insurance, and other settlement costs. So a lot of details are in there. You also see some provisions about breach. So it's important to understand that as well, because it is a legally binding contract. There will be some remedies. So if you have the seller breaching the contract, then the buyer would be able to go through steps and request specific performance, which just means that you want them to satisfy the contract as they've agreed to it. So essentially transferring the property to you on the terms. Or if you've, lost out money because now you can't actually buy the property, but you've done all the steps, you could seek monetary damages instead. If the buyer were to default, then typically the seller would say they're going to keep your earnest money, and who knows what else. But keep in mind that there are going to be some terms for breach and default in the contract as well that you should understand. Sometimes liquidated damages may be a term. It's not in the standard agreement that I received, but reading those terms also is important. And liquidated damages provisions could incur extra monetary damages or fees, expenses from whoever is breaching the contract. So we're going to talk more about contingencies and timeframes in the next few slides. Another part of the document that I will share with you all today is a real estate representation contract. And this is an important document. If you sign one, to make sure you keep it, a copy of it, and you understand what the buyer is obligated to do, or I'm sorry, the agent is obligated to do for you. But basically, these contracts will outline the role of the real estate agent in the transaction, in terms of how are they going to help the buyer from your perspective, or the seller if you're selling the land. These are standard types of agreements that are drafted by the Association of Realtors. And I would say it's really important to read this, understand what your agent is, obligated to do for you, how they're going to help you out. They'll often include a time limit, so a time frame where that agreement is good for. And so basically within that time frame, you're agreeing that you're going to only work with that agent as they help you find a piece of property for you to buy. And so even if you go into, you initiate a purchase agreement during the contract, and then it doesn't close until after the contract expires, they're still covered in, that agent is still entitled to their fees and things like that, and satisfying their role until the end of closing for any transaction that initiated during their period. The biggest thing for this is to remember there is the possibility for dual agency. So if you're shopping around for some property and you don't have an agent yet, and so you reach out and you're talking to this, that's fine. You can agree to have the one agent represent you and the seller, but you have to sign an agreement, because there's always the potential for some conflicts of interest there, because it's hard for them to equally protect the seller's interest and the buyer's interest at the same time. So it's typically best to work with your own buyer agent and a seller agent separately, because then you know that they are looking out for your interests and not having to do a balancing act to do that. And as I mentioned before, an agent can be really critical in helping you locate and evaluate the suitability of different properties, and helping you through negotiations and asking questions and things like that. They're just very knowledgeable individuals when it comes to real estate. So it's always good to have someone on your team that can help you with that. And then throughout the negotiation process, hopefully the realtors, that your agent is going to be on your side to help you do some negotiation, but the due diligence really comes down to the buyer if you're in the situation of buying property. And by due diligence, we're talking about doing some research, that a reasonable person would do to make sure that you're taking steps to understand what you're buying, understand the terms that you're agreeing to. Typically, you have to do your due diligence. You can do some due diligence activities, like I said, before you make an offer, before you enter into a purchase agreement. But there may be things that you can't find out until, you get more comfortable and you are allowed to access the property, and you want to kind of put it on hold because there's only a few things that are left, right? And so it can be, those contingencies can be incorporated into your purchase agreement. But once you've signed it, and if you close, you've assumed that all those due diligence activities have been performed. And like I said, there's going to be a defined contingency period, typically 90 days, where you're going to ask for all of these tests or waiting periods to be conducted. And you're looking at the results within that time period. And if you, don't contest something and you still sign it and you go forward, then you won't have that to fall back on as something like that was misrepresentation down the line. So I'll go through some of the provisions now and talk about some of those due diligence steps that you can take to protect your own rights and protect yourself in the process. So the first one would be description of property. Typically, real estate, their description is going to be given in acres or maybe square feet, more or less, right? you may be able to get like a footprint, like a map of the property, right? But if you're doing a purchase that's based on like a price per acre, it's going to be important for you to know exactly how many acres you have, not more or less, really, if possible. And it's also, thinking about like, how are these land records recorded? With the Office of Land Records, the deed may be something that's been handwritten, who knows, 100 years ago or so, right? And so it can be hard to interpret or hard to read. And there's no guarantee that the acreage that's listed in the deed is actually the acreage. So you may request a survey if one hasn't been done recently as a way to determine what the actual property boundaries are and the acreage is. That can be included in your contingency, requests. But like I said, if it hasn't been done recently, and it'd also be a really good idea to ask if it has been done and there's neighbors, because I feel like property boundary disputes do come up pretty often. So like fence lines and things like that. And so, yeah, there's a fence there and you can safely think that that would be your property line, but unless you have a survey that says that, it's not, you can't always assume that when you're making the purchase agreement, when you're making that purchase. And then you have a provision there that talks about, oh, this is the fun one. Okay, we're going to talk about this for a while. Buyer expressly assumes the risk that restrictive covenants, zoning laws, and other recorded documents may restrict or prohibit the use of the property for the purposes intended by the buyer. It's important to know that, like, even if the seller knows what you want to do with the property, they don't have to make a guarantee that the property is suitable for your purposes. So it's up to you, the buyer, to do your due diligence and do some research. A lot of times you'll hear about property rights as like a bundle of rights, your ownership rights that you can do with your property, like whatever you want to do. You can cut down trees, you can build stuff, you can take out the mineral, like anything that's in the soil. You can hunt and fish on your property. You can let other people use your property if you want. That's the typical bundle of rights that you'll get, right? But a lot of times there's going to be restrictions. It could be a covenant, it could be an easement, it could be zoning restrictions, or there are things like that. And so understanding, doing that due diligence is going to be really important for you. You're also potentially going to see some terms that relate to like a forest conservation and management plan. So if the previous owner has entered into an agreement with the Maryland Department of Natural Resources, that would be something that you could potentially have to look up and decide if you want to comply, carry on that agreement. A lot of times you're going to see things like floodplain disclosures. What's not really a disclosure, it's like a floodplain notice, and it's up to you to go see if it's in a floodplain, and if you need floodplain insurance. A wetlands notice. So sometimes, hopefully the buyer can provide this information, but I'm just letting you know that these are notices that are going to be in the agreement. And in the agreement, it outlines that it's the buyer's responsibility to go and check if these things apply. So like a wetlands is a piece of property or any part of the land a wetland, or is any part of it within the Chesapeake Bay critical area, protected area, which would have restrictions on what you can build within a certain distance of a waterway, things like that, restrictions on what you can build and the types of permits that you would need. So those are some of the other provisions that you'll have to really read closely and ask the seller if they have that information already. And if they don't, then go and do some extra research. So as far as zoning goes, it's not super easy, but not too hard to do some research based on the county that the property is in. You can always go and online now, which is really nice for the most part. You can search for the zoning map. And you'll see, I'm not sure how easy it is for you to see this, but there's some little letters and numbers in here. So this is RC2, RC5, I think RC4. You'll get idea for different zoning categories in your county. You can always get a map. And then you can go into the ordinances for your county and look up what that zoning code means. So RC2 here means agriculturally zoned. So this little portion right here is agriculturally zoned, and it'll give you a list of, by right, what you can do on the piece of property. like I mentioned before, like definition of agriculture, what you're permitted to do without having to go and get permission, things like that. Use restrictions are also included in there. It may be looking like a table instead of just a listing, and a table could be very large and sort of tedious to go and look through. ALEI does have a video tutorial to help you sort of do these steps also. But also keeping in mind that there may be density restrictions on like how many houses you can build per acre in certain zoning areas. So if you are looking at a piece of property and you have the idea that you want to build a house on it or an extra house, thinking about what are the density restrictions for that zoning area. And they're going to be different for urban areas as well. And don't assume just because the property is being used for a farm right now or has a certain component to that farm operation right now, that that's something that you can also carry on, because they may have a non-conforming use, they may have a special exception for some reason. So, that when you take ownership, you may not be able to continue on that use. So fully understanding the zoning of the piece of property, very critical. Thinking about your neighbor relations as well early on, I don't think is a bad thing. It may be hard to really connect with the neighboring properties, but if you're able to, you do the property walkthrough, check out what's surrounding the property, if there's people close by. Because even if something that is allowed in the zoning, there's no guarantee that your neighbors are going to be okay with it. If you want to start kind of switch up the use of the property, like if you want to have an agritourism, you're going to have more traffic going by into the property, that may be raising an issue at some point in the future. If you have certain lighting requirements for your growing operation, you're going to start using fertilizers or pesticides, or raising livestock, or even composting on your farm. Like these can all be issues that come up with your neighbors down the line. So if possible, talk to people, walk around, see what's going on there. And just get familiar with the space. I know for urban agricultural operations in some places, like if you wanted to do an urban agriculture thing where you're also raising like poultry, sometimes in some counties that requires approval from all of your neighboring properties. So, if you're looking at a piece of property with that in mind, before you actually close on it, talking to your neighbors, let them know and say, hey, potential neighbors, that's something that's coming up, would be good, because they could, you could close on the property and then your neighbors could not be on board and they could stop you from doing what you wanted to do with a piece of land. Conservation easements are also a big one. So they often, oh gosh, there's so many, there's such a big thing. The good thing is, so conservation easements are pretty common. I feel like they're kind of common in a lot of rural properties. They're a way to remove the development rights from the property itself, so it stays in agricultural use. And they're issued by a number of different organizations. There's county and private and state organizations that do easements in Maryland. And it's important to remember that they restrict development rights, but they can also restrict other, the ability to build farm buildings on the property in the future. They restrict the ability to build houses for the farmers to live in the future. But just because a piece of property does have an easement on it doesn't mean you necessarily couldn't do what you want to do, because each easement itself is a contract that has been negotiated by the previous owner, whoever negotiated that. So maybe they put in there a term where they want to be able to build X number of houses on the property and they haven't reached that limit yet. So, it's important to say, like, get a request. There is a requirement for an easement on the property to be disclosed in the agreement. So you would have the opportunity to review the easement terms in advance before the closing. And even maybe before you take an offer, put an offer on the property, if you want to reach out to the agent and ask for that information. But don't rule it out just because there's an easement on the property. But it's definitely important to understand what those limitations are, because they run with the land and they would be binding upon any new owners as well in the future. And then if you're interested in a piece of property that does not have an easement on it, keep that in mind, because that may be an opportunity if you're interested in entering an easement, to help reduce the cost of the land for you, because, Marbitco Next Gen program has, helps finance, and then the purchase of the property with the understanding that an easement would be entered into. And because, they're buying the development rights, there's a chunk of money coming in that could be used to pay back the lender, Marbitco, in that situation. So they're restrictive, but also potentially an opportunity to help reduce costs in that sense. Other types of easements that could come up besides a development easement are private ones. So if you are able to walk the property and see, is there a shared driveway with the neighboring property? So there's an easement there where both owners have access to that driveway. Are there paths that are well worn, people are cutting across? Are there utilities like power lines or other things on the property? Because utility companies often will have an easement to access a piece of property if there's a line to do maintenance and things like that. Maybe there's an easement for hunting rights, things like that. I mean, these are possible in rural areas, but also in urban or suburban areas. They may not be recorded in the land records, so it's important to really ask the existing owner about it and get information. Things like driveway easements could be in the deed agreement and recorded, but do your due diligence. Ask the owner about any types of paths and things like that that you notice when you do a walkthrough of the property. And then here's a link to the tutorial on how to go through and look at land records, because it can be kind of a tricky to read those documents and navigate the system online. Okay, some other provisions are, oh gosh, we're getting close. Farm crop timber rights. So if on the piece of property it's already being farmed, there's an existing lease, maybe you'll typically have a provision in there that allows the current tenant or the owner to come and harvest the crop that's in the ground already. If there is an existing lease agreement, it's important for you as a buyer to get a copy of that lease and understand the terms, and understand that the current owner is restricted from entering into any type of new lease. If you're in the negotiation, like you put an offer in and you have a purchase agreement and you're moving toward closing, they wouldn't be able to enter into or extend an existing lease during that period. Maybe you want to work the property and you have to honor the rest of the lease, but then making sure you go through the steps and about terminating that lease agreement with the current tenant, to keep it something to keep in mind, to review that document as well. Then you're going to have a provision like this where it's basically as is. It's the buyer beware provision, where the seller is saying that there's no implied warranties on this piece of property. They're not guaranteeing, like I said, that it's suitable for your purposes, unless there's something that's included in the purchase agreement, like all of these contingencies that we've been talking about. Like, what do you want to include? So if you want inspections, you have to include it. If you want an environmental inspection, a home inspection, if there's a home on the property, include it in your purchase agreement. What is the result that's going to allow you, the buyer, to back out, or will the seller have the opportunity to remedy something that's not up to code, or will the buyer just walk away and then get your deposit money back? So putting that information in the purchase agreement is critical, because the default is as is, no warranty. Environmental inspections can be a big thing on rural properties and in urban properties. Typically, you're looking out for whether there's underground storage tanks, if there's any contamination on the property. Has there been previous chemical use, like pesticides? Is there any evidence of spills in the area, things like that? Is there mold or lead paint typically within structures or homes? Things to keep an eye out for and ask questions about. So if you see something, you ask about it and then get that response. Decide whether you want to have soil analysis or soil tests done as well. You can look at the soil map. There's a web soil survey online to get an idea of the types of soils in the area of the property, to base those, kind of like a baseline, and then get some tests done if the seller has been doing tests, for them to share those results with you and the location of where those tests, those samples were taken from. And so if you see areas of concern that you notice like haven't been tested, you can put in a contingency that you want soil in this particular area where maybe there's evidence of a spill to be tested for yourself. Other things are contingencies are for water quality tests or sewage disposal systems. So making like a percolation test to indicate whether there's suitability for installation of a private on-site sewage disposal system if you need that, or the well water quality or quantity, or your ability to connect with some sort of public water source that's potable. That can be an issue sometimes if there's no hookups. I put a note here for TBA because I know MDA, the Small Farm and Urban Ag Program, I don't know if it's been released yet, but there is a grant program in the works to help give small and urban growers that are on pieces of property that don't have those hookups, to give them some grant money, like cost share money, to help pay for those types of hookups if you don't have them. I'm not sure it's been announced yet, but that's something to keep your eye out for. And then you're also going to want to include in your purchase agreement any types of inclusions of what's being transferred with the property. So are there like fences, gates, sheds on the property, like barns, other items like that? If it's like, a dairy and there's like a whole dairy barn with equipment in there, is that also being transferred with the property? It's good to have all that information included in an addendum to the purchase agreement. And then property insurance is another thing. So if you're financing, which most people would do, the property, the lender is going to want to have some property insurance. And so this could be a good opportunity to have, contact your insurance agent and let them know, hey, you're thinking about buying this piece of property. If there's structures on the land, have them come out and do a walkthrough or maybe share pictures with them if that's more feasible. But particularly if there's hazards or insurance risks on the piece of property, like some dilapidated buildings that are not up to code, if there's a pond on the property, any types of uncapped wells, things like that, it's important to talk to your insurance agent ahead of time to see if it's going to make your insurance rate, how much is it going to cost you for insurance on that piece of property? Is it going to be like unduly high because of these risks? And just getting an idea of what those expenses are going to be as well. Some other small items are like to put in the contingency. If you are doing the property as a part of a business, maybe you want to have a contingency that all your business partners are going to approve the purchase agreement terms before you go forward. Or if you're part of a corporation or cooperative, your board of directors will approve it. If you're like I said, if you're doing FSA financing and you don't know if you're going to have all of the financing available yet, a contingency term can be approval of your loan application or your financing to come through. And then finally, the Ag Declaration of Intent is also going to be a document that you'll sign. And you basically, just like it says here, if the property is assessed in the agricultural use category in Maryland, and the buyer does not intend to use a property for agricultural purposes, the ag land transfer tax could become due and can be substantial. It could be a lot of money. So to avoid the tax, if you do intend to farm that piece of property, you would sign a promise and intent to use the property for agricultural purposes for at least 5 years following the sale. And we do have a blog post link here for more information about that ag transfer tax and the declaration of intent form, for more reading about like how much tax would you be due and when would you have to pay it back and things like that. That's in the blog post for you. Okay, so I flew through all that. I want to say a big thank you to Margaret Clune Gibson, who helped me, who's a part-time legal assistant at ALEI, for us to help put together the slides. And also thank you to Bob Rich, who is an ag realtor in Maryland, who helped provide the general contract for us to look through and get some feedback. And I also would say, if you're interested in talking to a real estate agent who's familiar with farmland purchases in Maryland, he could be a great resource and person to reach out to as well.
Great. Well, thank you very much. That was excellent information and really important when you're making that big investment, right? So
Yeah.
land is one of the largest investments farmers make. So um, there has been some comments in the chat just about where to find land, and some of people included some links there. FarmLink was mentioned. There's some beginning farmer rancher coalitions, some other types of like classified areas. Think it's very hard. It's still very much word of mouth, I think.
Mhm.
So yeah, trying to identify property can definitely, I think, attending some community meetings, talking with neighbors. I see a lot of things that kind of happen not on forums or classified ads or, real estate
Mhm.
postings.
Maybe like driving around the neighborhood that you're interested in,
Mhm.
looking for those for sale signs, for lease signs. Let's see. Any other questions? Another resource. Yeah, that's great. So I know that's a lot.